Welcome to the Public Housing Repositioning Post-Closing How-To video series. The goal of this video series is to help explain and discuss common issues that occur post-closing during public housing asset repositioning. Each video provides quick guidance to public housing agencies, PHAs, that are new to or unfamiliar with RAD and/or project-based voucher (PBV) program requirements. The videos will help PHAs better understand their asset management and reporting responsibilities post-repositioning and clarify resident rights. The videos provide information to PHAs that have converted their assistance from public housing to voucher assistance as part of repositioning. This video will outline PHA responsibilities once they have closed a RAD PBV transaction. Some videos in this series highlight program features that are applicable to both RAD PBVs and non-RAD PBVs. This video describes a process applicable to both, as well as regular HCVs. The video is broken into two main topics. First, we will review when an independent entity is needed by looking at the definition of PHA-owned units and when the definition applies. Then, in the second half of the video, we will apply the definition and look at 7 scenarios. In this section, we will review how to define a PHA-owned unit, when the definition applies, and when a legal opinion is required. If a unit is PHA-owned, the PHA must identify and use an independent entity to perform certain functions concerning the project. So, it is important to understand what it means to be a PHA-owned unit, since that is what triggers the need for an independent entity. Now we will review the definition of PHA-owned units. Previously, a PHA-owned unit was only defined in regulation. With the passing of the Housing Opportunity through Modernization Act, or HOTMA, in 2016, now PHA-owned units are defined in law. The new definition of PHA-owned applies to all PHA-owned units, including units rented under the HCV program, units bought under the homeownership option, and units project-based under the PBV program. The new PHA-owned definition applies to PBV HAP contracts and AHAPs executed on or after April 18, 2017. So this means, for PBV HAP contracts and AHAPs executed before April 18, 2017, the old PHA-owned definition applies, though in many cases the project will be reclassified under the new definition after the PHA gets a legal opinion regarding the ownership status. We'll discuss this further later in the video. And for all PBV HAP contracts and AHAPs executed on or after April 18, 2017, the new PHA-owned definition applies. A PHA-owned unit is a unit located in a project that is owned by the PHA, including the PHA having a controlling interest in the entity that owns the unit, owned by an entity wholly controlled by the PHA, or owned by a limited liability company, LLC, or limited partnership in which the PHA, or an entity wholly controlled by the PHA, holds a controlling interest in the managing member or general partner. So now we will look at what it means to have a controlling interest. Having a controlling interest means any of the following things: holding more than 50% of the stock of any corporation, having the power to appoint more than 50% of the members of the board of directors of a non-stock corporation, such as a non-profit corporation. More than 50% of the members of the board of directors of any corporation also serve as directors, officers, or employees of the PHA. Holding more than 50% of all managing member interests in an LLC. Holding more than 50% of all general partner interests in a partnership. Having equivalent levels of control in other organizational structures. Now we will take a closer look at other meanings of control or ownership that have different implications in some circumstances relating to PBVs or RAD PBVs. What if, under a RAD conversion, a PHA has been deemed to have sufficient control or ownership over the converting project? RAD uses a different definition of ownership or control for purposes of HUD's requirement for ownership or control of the covered project by a public or nonprofit entity for RAD conversions. Therefore, a project may have a level of PHA ownership that meets the RAD definition of ownership or control, but may not be considered PHA-owned under the voucher program definition described previously. In such a circumstance, the PHA would not be required to use an independent entity. Now what if, for a non-RAD PBV project, a PHA has an ownership interest such that it is able to select the project non-competitively? It is important to note that HUD uses a different definition of ownership for purposes of HUD's criteria for non-competitive selection of non-RAD PBV projects. Therefore, a project may have a level of PHA ownership that meets the definition of ownership for purposes of non-competitive selection, but may not be considered PHA-owned under the voucher program definition. In such a circumstance, the PHA would not be required to use an independent entity. Now that we covered the basic definitions, we will go back to the original question. Do you need an independent entity? Will your PHA have any PHA-owned units that have or are proposed to have vouchers attached to them? If yes, then you need an independent entity. If no, then you do not need an independent entity. Next, we will walk through 7 scenarios to put this concept into practice. The 4 main players in the scenarios are the Housing Authority A and a property called the View Gardens, which will receive PBV assistance, and ABC Corporation, which works with the Housing Authority A, and XYZ Inc., which is a non-profit organization that works with the Housing Authority. The first 4 examples will look at how to identify a PHA-owned unit based on the definition. The next 2 examples will look at when the definition applies. The last example will look at when a legal opinion is required. In our first scenario, 4 of the 6 members of ABC Corporation's Board of Directors are also employees of Housing Authority A, but none of them perform any work directly related to Housing Authority A's HCV and PBV programs. ABC Corporation owns the View Gardens project, which was selected by Housing Authority A for PBV assistance. In this case, the units are considered PHA-owned. This is because the Housing Authority A has a controlling interest over ABC Corporation, because more than 50% of ABC Corporation's Board of Directors are also employees of the PHA. In this next scenario, the Housing Authority A owns the land where the View Gardens project is located. Housing Authority A has no ties to ABC Corporation, the entity which owns the View Gardens project, and View Gardens is selected for PBV assistance by Housing Authority A. In this case, the units are considered not PHA-owned. This is because the Housing Authority A owns only the land, but has no ownership of the project or any ties that would result in a controlling interest of ABC Corporation. In this third scenario, the Housing Authority A can appoint 3 of the 6 members of the Board of Directors of XYZ Inc., a non-profit organization. XYZ Inc. owns View Gardens, a project that was selected by Housing Authority A for PBV assistance. In this case, the units are considered not PHA-owned. This is because the Housing Authority A has no controlling interest over XYZ Inc. because they can appoint only 50%, not more than 50%, of the Board of Directors of XYZ Inc. In our last scenario, Housing Authority A holds 51% of ABC Corporation's stock. ABC Corporation owns the View Gardens project, which was selected by Housing Authority A for PBV assistance. In this case, the units are considered PHA-owned. In this scenario, Housing Authority A has a controlling interest over ABC Corporation because they hold more than 50% of ABC Corporation's stock. Now we will look at when the definition applies. Remember, the new PHA-owned definition applies to PBV HAP contracts and AHAPs executed on or after April 18, 2017. So, what happens if a project is under a PBV HAP contract executed before April 18, 2017, but due to the definitional change, it is no longer considered PHA-owned? In this case, the project will remain classified as PHA-owned for purposes of program requirements and monitoring until the PHA obtains an opinion from its legal counsel that the project is no longer PHA-owned. And a second question: what if the ownership structure of a project changes in the future, and as a result, the project is no longer PHA-owned under the new definition? The same response applies in this case. The project remains classified as PHA-owned for purposes of program requirements and monitoring until the PHA obtains an opinion from its legal counsel that the project is no longer PHA-owned. Next, we will look at 2 scenarios to apply this concept. In this scenario, Housing Authority A executed a PBV-HAP contract with Smith Corporation for the View Gardens project on May 1, 2015. Housing Authority A also holds 45% of the stock of ABC Corporation. The PBV-HAP contract was executed prior to HOTMA, and it was considered PHA-owned under the previous definition. Given this information, the next step is to check with Housing Authority A's legal counsel. In short, Housing Authority A may discontinue the use of an independent entity for View Gardens after it has obtained an opinion from its legal counsel that View Gardens is not PHA-owned under the new statutory definition. In our next scenario, the Housing Authority A held 55% of ABC Corporation's stock at the time it executed a PBV-HAP contract with ABC Corporation for the View Gardens project. The HAP contract was executed on May 1, 2017. Housing Authority A has since sold some of ABC Corporation's stock, and it now holds 45% of such stock. Based on this information, the next step is to check with Housing Authority A's legal counsel. Housing Authority A may discontinue the use of an independent entity for View Gardens after it has obtained an opinion from its legal counsel that View Gardens is no longer PHA-owned under the statutory definition. As was demonstrated in the 2 previous scenarios, sometimes, in order to determine whether or not a unit is PHA-owned, a PHA's legal counsel may need to examine the specifics. Let's walk through a few commonly asked questions. Am I required to seek an opinion from my PHA's legal counsel in all cases where my agency determines that a project is not PHA-owned? PHAs are required to seek a legal opinion only if 1. The April 18, 2017 change to the definition of PHA-owned caused a project that was PHA-owned to no longer qualify as PHA-owned, or 2. A project that is PHA-owned changes its ownership structure such that it is no longer PHA-owned. However, the PHA may want to seek a legal opinion in all cases where the agency determines that a project is not PHA-owned. What must I do once my PHA's legal counsel renders an opinion? Keep the legal opinion in your files for the length of the PBV-HAP contract, the HCV-HAP contract, or home ownership assistance as applicable. If the legal opinion specifies that the project is no longer PHA-owned, you are no longer required to use an independent entity to perform the applicable responsibilities concerning the project. What if the ownership structure of a project changes in the future, and as a result, the project is now considered PHA-owned? The PHA must tell the local HUD Field Office of Public Housing, in writing, within 30 days of the change in ownership, the proposed independent entity that will perform the applicable independent entity responsibilities. In our final scenario, we know the Housing Authority A held 25% of ABC Corporation's stock at the time it executed a PBV-HAP contract with ABC Corporation for the View Gardens project. Housing Authority A has since bought more of ABC Corporation's stock, and it now holds 51% of such stock. Given this information, View Gardens is now considered PHA-owned under the statutory definition. It will need to use an independent entity. Since this is the case, Housing Authority A must tell the local HUD Field Office of Public Housing what proposed independent entity it will use for View Gardens. Thank you for watching this video.